Thank you, Angie. Thank you, council, for agreeing to participate via Zoom. We know that this is not the best situation, but it's the best situation that we can keep the cases moving at this juncture and making sure the appellate process works. We appreciate you and your clients agreeing to do this. Before we get started, I need to run over just a few ground rules, make sure everybody understands what we're doing. First of all, both of you are experienced appellate practitioners, so you understand how the process works. Each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, please request that from the court prior to, after you've introduced yourself and prior to you making your argument. And of course, you may reserve up to 5 minutes of rebuttal time. Obviously, the appellee gets no rebuttal time. Want to introduce the panel for today. Your panel is Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg. I also want to thank Jim Hibner and Angie Dempsey for being the people who make this stuff work. I don't know how it works, but I know that they make it work, as well as the AOC technology staff, and we certainly appreciate them. Angie, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case, please.
Mini Systems, Inc. versus Marvin Alexander et al.
Okay, we'll hear from the appellant.
Good afternoon, Your Honors. My name is Keely Wilson, and I represent the appellant, Marvin Alexander, in this particular appeal. I have requested 3 minutes for rebuttal.
All right, you may proceed.
This particular case is a construction case for a breach of contract, along with a Tennessee Consumer Protection Act claim that Mr. Alexander filed. This case was tried without a jury in front of the Weakley County Chancery Court. The court entered an order in September, and they dismissed the appellant's claim regarding the TCPA claim that was filed, as the court found that the appellee's conduct, and the appellee's Mini Systems in this particular case, that their conduct was not intended to deceive, and it wasn't intended to be fraudulent. So therefore, the chancellor thereby dismissed the TPA claim, indicating that any conduct was the result of a misinterpretation of some plans. Therefore, we filed this particular appeal on 2 bases. Our first basis is that the trial court erred in determining that the appellee's conduct was not intentional. And secondly, the trial court erred in failing to consider whether the appellee's conduct was negligent and therefore violated the Tennessee Consumer Protection Act. And also whether attorney's fees can be awarded under the same. In this particular case, this was a contract that was entered into in between Mini Systems, who is the appellee, and my client, Mr. Alexander, who is the appellant, for the construction of 2 mini storage facilities. That particular contract was entered into, and a amount was determined for the total contract price of $174,614. The contract was entered into, and the contract provided for that the buildings would be constructed by Mini Systems, both the concrete slabs for each building as well as the buildings themselves. Now, the contract also provided that Mini Systems would in fact construct all facets of the construction project, the slabs and the buildings.
Ms. Wilson, in the complaint, it's just a very general allegation of a violation of the Consumer Protection Act. There's no particular section of the act that's cited, and you have to fall within one of the specific provisions of the act And I'm not clear on where you're saying there was a violation of the act. What part of the act are we talking about?
We filed our claim under the catch-all provision, basically the 47-18-104B7, which indicates that you cannot provide a good or a service that is not what you claim it to be.
And what is the good or service here?
The concrete, as well as the building materials.
Okay, and how do you relate that? How are we relating this to being a violation of the Consumer Protection Act?
We are relating this because of specific practices that many systems conducted. They themselves designed this project specifically for Mr. Alexander. Mr. Crutcher, who is an owner of Mini Systems, who's not an engineer, designed and formulated the plans. He then sent plans to an engineer in Texas to plan stamp, which is illegal. But in any event, the plans called for specific areas of the concrete, how the concrete was to be poured, and the contents of the concrete. Those specific items were not followed. What was done was Mini Systems, in an effort to reduce their costs, provided an inferior product than what was promised in the contract, not only with the concrete, but with also the building itself, because some parts of the building were called to have particular items, and they were constructed with inferior items, as well as, I'm just gonna say the concrete, for example. The concrete was supposed to be poured in 2 different pours, which allows for a better integrity. It was supposed to be poured so thick, and it was not done. It was supposed to have so many saw cuts in it. That was not done.
Well, assuming all these things are true, how is this not just a breach of contract case?
Well,
Which the trial court found that it was.
I think the case, like I said in the brief, is analogous to Holiday. I think there's several specific instances where Mini Systems conduct was not only deceptive, but it was unfair. Specifically, when my client filed an inspection sheet after the second slab was poured, with some complaints regarding the slab, the CEO of Mini Systems emailed him. This is a month after he has paid for everything. He has simply sent an inspection sheet to the company to say, I have some issues with the concrete. I want you to come and look at it before I pay for it. And Mr. Saripkin told him in an email that's included in the transcript, if you don't pay now, I am going to, and I'll quote it, I'm going to push you to the bottom of the list. I will file a mechanic's lien to give us automatic payment if you ever sold the property. I will file a restraining order against you, and this action will stop you from proceeding with any building on the property until we are paid. Since legally the second slab is ours, not yours, you will never be allowed to build on this slab. We will sue for loss of income, and we will file a lawsuit. And he indicated that he did this in an effort to get him to pay. He said in the email, which is part of the record, you should seriously consider what I have said. We will not hesitate to recoup our monies which you agreed to pay. If you can believe you can fare better in court, that's your prerogative. But I would seriously recommend getting your legal team together to defend this case. In addition,
Does that make it a Consumer Protection Act case? That's my question. I'm trying to figure out.
I believe it does. I believe that goes to the absolute essence of what the Tennessee Consumer Protection Act does. It is designed to protect a consumer from unfair or deceptive practices. That email in and of itself says, I'm a business, and if you complain about anything that I do, I'm going to sue you. I'm going to put a lien on your property. I'm going to do everything. I'm going to put you at the bottom of the list. That is not an acceptable practice in the state of Tennessee. Not only did many systems do this particular conduct, but also right after this email was sent to my client in September of 2014, many systems then told my client, before you get those materials to for us to build the buildings, you have to pay us in a cashier's check. That was not included in the contract. Mr. Saripkin, who is part owner of many systems, testified, I told him this to threaten him. Those were his exact words, to threaten him into paying. I don't believe that. I think that this particular conduct is exactly what the Tennessee Consumer Protection Act protects consumers against. Is that if you complain, or you better not complain, or we're going to do all this to you, and I'm going to try and threaten and coerce you to pay. In addition, not only that, but he said many systems will file a lien against your property if you fail to pay. My client paid for everything that he was supposed to pay for until the very last payment because the punch list was not completed. And the trial court indicated he had every right to withhold that last payment because the building was not complete. And so he withheld that payment. As soon as he withheld that payment, asking many systems to come and remedy the punch list, which every person has a right to do, Mr. Saripkin placed a lien on not only that particular property, but on 8 tracts of property my client owns. 7 of them have nothing to do with this particular property. I think all of those particular acts and conduct, the threatening emails, saying you're going to pay or I'm going to place a lien, placing 8 liens when obviously they were improper, I think that goes to the essence of the Tennessee Consumer Protection Act. And I think it is I think I have a minute and 40.
Minute and 40 seconds.
As well as, this is not just a breach of contract case. The court ruled they breached the contract, and they did. Not every breach of contract is a Tennessee Consumer Protection Act case. I agree with that. It's only when the business's actions are either unfair or deceptive. And they don't have to be, under the TCPA, they do not have to be intentional. They can be negligent. In this particular case, Judge Childress ruled that he did not believe that many systems' actions were intended to defraud or intended to be fraudulent. Therefore, since he didn't find that they were intentional, there was no claim. But he failed to consider whether or not they were negligent, and which is an actionable matter under the TCPA claim. Because what was he premised his verdict on the fact that many systems mistakenly poured the concrete under a different version of what the engineer suggested. No engineer drew these designs. Mr. Crutcher, who is half owner of many systems, he's the one that drew the designs and designed it specifically for Mr. Alexander. There's no way that Mr. Crutcher could misinterpret his own drawings. And therefore, they provided a product that was not represented in the contract.
Okay, thank you for your argument. We'll hear the appellee. You still have 3 minutes for rebuttal.
May it please the court.
Can't hear you, Mr. Barnett.
Let me see. Maybe we're muted or something. Can you hear me?
Yeah, now we can hear you, but I couldn't hear you for a moment.
All right. First off, may it please the court. And Judge Golden asked what provision of the act is applicable, and the provision that was cited for the first time, as far as I know, by the plaintiff in this case, or appellant in this case, was subdivision B27, and it says subdivision B27 is invested exclusively in the office of the Attorney General or Reporter. There's no private action for that provision of the Tennessee Consumer Protection Act. There was a quote from Michael Serepkin by Ms. Wilson. I don't know how that could be, because Michael Serepkin didn't testify in the case. He was not a witness, and so he couldn't have said what Ms. Wilson says. And then secondly, most of this argument that you're talking about wasn't argued in the brief or wasn't part of the case. But let me give you a little bit of background about the case, and that is, here's what I think would be super important, and that is, Mini Systems has been in business for 30 years. They build about 150 of these mini storage buildings per year. In their 30-year history, other than Marvin Alexander, they've never had anybody sue them. They've never had any complaints with building boards. They've never even had to sue somebody except for Marvin Alexander to collect their money. This case revolves around primarily around their claim that their ex post facto claim that was occurred and talked about after the dispute arose about a multi-pour versus a mono-pour. Mini Systems and every other builder of these types of building builds them with a mono-pour. And this is the way this one was built. This is the way that this one was the way that they built all 5,000 of these, and it is the industry standard as the judge ruled. And there were no witnesses that testified that this was not in accord with the industry standards. There weren't any witnesses that testified that there were any deceptive or unfair acts. Now, the judge did rule that there was a breach of contract, and that this particular contract called for something in excess, apparently, of the industry standard, and didn't make an award. Now, we certainly don't agree with that, but we haven't appealed it, so we've waived that issue, because this case took 6 days to trial with 9 witnesses, 3 expert witnesses, and Mini Systems was ready to be to just not do business with people like Mr. Alexander, because they'd satisfied 5,000 other clients. And so even if there was a breach of contract, which the judge ruled and we're not appealing, there's no evidence that there was a violation of the Consumer Protection Act or there was any kind of deceptive acts. The first place that you look at perhaps are the issues that are framed by both parties. If you look at the issue as framed by the appellant, well, first off, it doesn't specify any part of the Consumer Protection Act that was violated. It doesn't say number 7, number 27, number 47, or anything. It says acts can be. The Tennessee Consumer Protection Act provides for relief of victims for deceptive acts. The acts can be negligent or intentional. Okay, well, that's true. But there was no evidence that there was either an intentionally deceptive act or a negligently deceptive act. It is true that Mini Systems poured the slab intentionally in accord with their belief of what the plans call for, and they intentionally poured it in accord with their interpretation of the plans, and they intentionally poured it in accord with the way that they have built 5,000 other ones and the way everybody else built one. So I would assume that the word intentional in terms of the act means something that's intentionally wrong or willfully wrong or intentionally deceptive. There wasn't any negligent because many systems didn't negligently pour a mono pour. That's the way they pour them all. Okay.
Well, doesn't it have to be one or the other? Because whatever they didn't do served as the basis for the breach of contract action. In other words, the court determined Mr. Alexander was supposed to get some specified service, and he didn't get that. So it was either they intentionally didn't give it to him or they negligently didn't give it to him.
I would respectfully disagree with that, Your Honor, and that is that something a breach of contract has to be either an intentional wrongdoing or has to be negligent. Let's say we have a case such as this in which we've got a set of plans and we say that this is the way the plan is interpreted, and they say that this is that it's interpreted a different way. We have a disagreement, but all disagreements, at least in my mind, don't have to be negligent or intentional or deceptive. I mean,
What else do you call it?
Dichotomous choice.
You just call it a disagreement?
Dispute about how the plans were to be interpreted, right? I mean, something can go wrong or be disputed without somebody being negligent or intentionally deceptive. But all right, let's say you're right, and that is, and maybe you are. You're the judge, so it has to be. Does that mean that everything, anytime that there's anything that's negligent, in other words, any kind of mistake is in some way negligent, that every case in which there's any negligence, that it's a breach of the Consumer Protection Act? And surely there has to be more than that. It has to be one of the 52 listed things. But I guess we get back to the same point. And in their brief, they say, or their statement of the issues, they say, intentionally decides to ignore well, they didn't decide to ignore the plans. They interpreted the plans the same way that they've interpreted them, then everybody else interprets them, and the way they've been interpreted 5,000 times before by many systems. They didn't intentionally do anything but do what they thought they were supposed to do and build it in accord with industry standards. Let me switch from that since the time's running out. The way this whole thing developed is completely different. Many systems signed a contract with Alexander to build these mini storage buildings. The contract called for the dirt work to be done by Marvin Alexander, who is a licensed general contractor with unlimited authority. It was supposed to be done within 90 days. Marvin Alexander took 8 months to get the dirt work done. And then he turned to Mini Systems and said, I've got to roll over some money from a sale, a 1041 or rollover. And I need for you to get this thing built within like 30 to 40 days. And they said, we can't do it. We've got other jobs. And he said, I want a $20,000 discount. They said, we're not giving you a $20,000 discount. We gave you a good price to begin with. He said before the first shovel of dirt was dug that he wasn't going to pay full price. And everything went downhill from there. Many systems tried to satisfy him, but were unable to do so. Eventually, Many Systems got everything built except for the erection of one building, and he wouldn't pay $11,000. A dispute arose, and Many Systems tried to collect their money. Marvin Alexander wouldn't pay them. They got into an email war, which Alexander looked up on the internet and started calling Michael Srepkin a sex offender. And so a lot of animosity developed between the parties. Eventually, Many Systems sued And certainly the Consumer Protection Act, the fact that they had an email war after they had a dispute is not a violation of one of the 52 listed things under the act. Michael Zerepkin didn't testify, so we don't have any proof in the record about all that. But even if he was rude and threatening, that's not to try to get the money he thought that many citizens would do. And even if Marvin Alexander said bad things about that, none of that has anything to do with the Consumer Protection Act. If you run through the witnesses, none of them testified to any unfair or deceptive acts. It may be just a help to the court if I briefly explain, what that dispute was about. But in terms of mono versus multi-pour, there is a diagram, and I think it's found on page 30 of our brief. And here's what that is about. If you look on page 30 of the brief, you'll see that there are two drawings, and they were on the same page or next to each other. The drawing on the left, according to all the engineers and people, is a drawing that would be easily interpreted as being a monopore. Remember, monopores are the way that they're all built. Now, the building inspector, big important thing here too is there was a building inspector who did testify. His name is Billy Stout. Stout was furnished a set of the plans. He came out and inspected the foundations, which showed a monopore, and he's familiar with it. And he approved. He came out twice, and he approved the foundation. All right, that's in accord with that. Now, if you look at the drawing on the right, you'll see that there's a box down at the bottom. After the dispute arose, they hired an engineer, Mr. Alexander did, one who wasn't licensed at the time he wrote a report, which is illegal, but that's probably irrelevant for our purposes. And that is, there's a line that goes across the top of that box. And so he said, well, there should have been at least two pours, instead of one pour. And that's what that dispute is about. And we say that since all of them are built, and that's the industry standard, no one testified that this was not built in accord with industry standards. The court basically held that many systems had to build it to a higher standard. We don't really agree with that, but we haven't appealed it, so we've waived that issue. Does the court have any questions about many systems position in this?
I don't see any.
Yeah, they mentioned one thing. They mentioned the Holiday case. If you took a look at the Holiday case, you'd see that it's not in any way similar to this case. And Holiday, the court specifically found that it wasn't built to industry standards, and there was, in fact, a misrepresentation, and it's not similar. I mean, one question you might ask is, could there be a negligent act that could be a violation of the Consumer Protection Act? And the answer to that is yes, they could. It could be, but this is not it. So if there are no questions, that's all I have to say.
All right, thank you. We'll hear from the appellant in rebuttal. Your mic is muted.
I'm so
Okay.
sorry. Can you all hear me now?
Cam?
Yeah.
I apologize. Just quickly, the appellee indicated that Mr. Zerepkin did not testify at trials. He did not appear. He did not appear at trial. However, his deposition testimony was read into evidence. So In essence, he did in fact testify at trial. His deposition testimony is part of the evidence and part of the record. We pled exactly TCPA 47-18-1047, specifically stating that we did not receive the goods or the services promised under the contract by the plaintiff. That is actionable. The mini system represented that the goods or the services of the contract would be of a particular standard, quality, or grade, and that the goods were of a particular style or model, and they were in fact of a different one. That is true in the fact that there was a deviation from the plans which called for a 2-pour instead of a monolithic pour. A monolithic pour provides, and this is all experts testified to this, provides for a weaker concrete because it doesn't set up. The monolithic pour also saves time and money, which is not what Mr. Alexander paid for. The concrete had fly ash added to it, and that also creates a weaker concrete but it cost less to do. And at this particular time, the contracted amount was already set in stone. So at that particular point in time, anything that was done to reduce costs was only going to benefit mini systems, not Mr. Alexander. So all of these items that they have done to reduce their cost, all it did was make them more of a profit and weaken the concrete and produce an inferior building that was promised in the contract that mini systems president designed himself. So there can be no misinterpretation of what was supposed to be done. The Holiday case is very analogous to this particular case because in that particular case, the punch list was not remedied, even though inferior items were provided and other than what was represented to the homeowner. The same thing happened here. What was represented that we were going to get for the $174,000 was not what we got. And the only explanation was, this is how we do it every other time, so why should we have done it any different with you?
All right, thank you, counsel. We appreciate your argument. We'll endeavor to get you an opinion as quickly as possible. Again, we appreciate you participating in this Zoom conference or Zoom video argument, and your clients participating as well. Ms. Angie, if you would recess us to the call of the next case, please.
This honorable court is in recess until 2 p.m.
Thank you.